Good afternoon, everyone. This is Marc Furman, and I'm trying to get to the screen. John, can you hit the advance button, please? There we go. I'm the one on the left, and my colleague, John Landesman, is on my right. And we are Chapter Labor Council for ABC of New Jersey from Cohen Seglias, Palace, Greenhall, and Furman. And we are going to be presenting this webinar on the coronavirus issues. Just as a quick reminder, for those people who are attending, you have the ability to ask questions. On the right-hand side, there's a pull-down box, and you can follow those instructions, and you can ask us questions. We will try to get to the questions eventually as they come in, but we may hold off on the questions until near the end. So without any further ado, we want to try to be respectful of your time. And Don, if you can click on to the next slide, please. Today's agenda, we're going to discuss the Families First Coronavirus Response Act, FFCRA. If you're not used to having acronyms, you're going to get lost in this presentation because there's a whole bunch of brand new ones from the federal government and so forth. So we're going to discuss that. We're going to discuss some coronavirus-related unemployment comp issues, and potentially the impact of workers' comp. We're going to discuss the WARN Act. That's the federal statute that deals with layoffs of a substantial nature. We're also going to discuss the payroll protection issues relating to federal loans, and we will have some time for FAQs. To get started today, John, if you can click on to the next slide, please. We're first going to discuss the FFCRA, which has been the subject of an awful lot of conversation, email chatter, etc. It was signed into law just a couple of weeks ago, and pretty much since that time, John and I have not slept. We have spent all of our time responding to questions relating to this. It has been a moving target because when the law was first enacted, there was not regulation, there was not guidance, and so there wasn't also a final version where the legislators went back and changed some of the provisions under the theory that, geez, I guess we didn't think that far in advance. John and I have been fielding questions, as I've said, and these questions tend to be actually rather unique. We're not getting the same questions necessarily all over again. We're getting new questions. And we've been giving advice. Well, while we're giving the advice, we find out that guidance has been issued by either the Small Business Administration or by the Wage and Hour Department or from the Department of Labor, which oversees wage and hour, that causes us to say, never mind, and we have to rethink our position and our advice. So you're going to hear throughout this presentation potentially situations where John and I would say, I would think mostly in response to your questions, we don't necessarily know the answer. We have an idea what the answer is or what we think it will be. So getting back to our slide deck, we have the law came in on March the 18th and essentially required small businesses to provide paid sick leave and separately paid family leave. When it was first put out by the federal government, the instructive material that came out from the Department of Labor referred to those two items both as paid sick leave. And so when we're trying to give advice, we're trying to explain to clients, well, what's the difference between the two? it was really hard to explain because the government gave them the same title. So they certainly didn't make it any easier for us. Originally, the law was to become effective not later than 14 days after March the 18th, and that would have made it April the 2nd. And then at the last minute, somewhere near the end of March, the law was made effective April the 1st. And people were wondering, well, geez, that changed. It didn't really change because the law said no later than 14 days after it was signed into law by the president. So April the 1st is certainly one day closer, but there was a lot of thoughts about why that came to be. Can we have the next slide, please? Under the law's definition, the FFCRA only applies to small businesses, and small businesses is a defined term within the law. It means that businesses that have 500, actually businesses of less than 500, you have the lucky 500th, you're kicked upstairs into another category, but is less than 500 people. And there are certain circumstances where certain large employers that have a lot of different locations could conceivably be broken down differently. But for the purposes of this seminar, that is not a particularly relevant subject for our attendees. So it's businesses of less than 500. Now, if you have only 2 people working for the company, you fall under this category. It's 1 to 500, or 1 to 499 is reality. And clients will say, but what happens if I have less than 50 people? I'm exempt from this law. You are not exempt from this law. You could be if you apply and get some type of a leave to be considered outside the scope of this law. That would be the next bullet point that you see on the slide. So if you have less than 50 people and you're able to assert that your operations would be jeopardized by the paid leave provisions, you could try to get an exception to this rule. And they do have it defined. Just because it might be difficult for you to be falling under the statute doesn't mean that it would jeopardize your business. And if you take a look at the guidance that came out, the business itself really has to be in jeopardy, where you're teeter-tottering on the edge of survival, as opposed to, I just don't really like this, and it's causing me to spend more money than I would otherwise like to do. That's not a good enough reason. So in order for you to be exempted from this, you have a heavy burden to overcome. Let's go to the next slide, please. Under this law, the employer is to provide certain benefits to its employees, which we'll get to in a minute. And the employer is really just fronting the money, and there's going to be a dollar-for-dollar tax credit for monies that you give to the employees. Now you might say, well, what does all that mean? It means that you will not have to make your federal income tax deduction payments to the federal government that you pull out of the employees' paychecks. You will not have to pay the employer's share of FICA taxes. Over a period of time, it will likely take, guessing, anywhere from 3 to 4 times the time period involved for you to recoup those dollars. So yes, you do have to lay the money out when it comes time to making the tax remittances. Typically at the end of every month, you would not do that. You would take a credit against tax payment, and if you still have money that you haven't used up, then you would simply carry that over to the next time period. The bill itself provides some clarification on what that is all about, and I would recommend that instead of speaking to your lawyers about this, the best source of this information would likely come from your accounting firm or whoever is doing your payroll, because that's where the rubber hits the road in terms of the details of how this is to be executed. The FFCRA has two basic provisions. There's paid sick leave, which is for sickness, and there's paid family leave. What the difference between the two will be obvious when we break down what those elements are. But effectively, the paid family leave takes the existing Family and Medical Leave Act and adds on to it a compensatory aspect to it. Also, there's an issue of what constitutes salary and fringe benefits, wages and bennies. Under the paid sick leave provision, and forget for a moment who is eligible for this, that'll be on another slide. But if there is paid sick leave to be taken, that would be up to 80 hours, which is 2 weeks of pay. How much of that and who's eligible we'll get to in another slide. The employer is not permitted, as you may have in your various handbooks, especially ones that Don and I have written over the years, where we indicate that any compensable time off, PTO, personal days, sick days that are paid, whatever, would be used in this circumstance before the company has an obligation to pay outside of those fringes. That is not the case with the paid sick leave. Whatever paid sick leave the employee has is, or PTO time or personal time or vacation time, whatever they have that is compensable time off is separate and apart from the paid sick leave, and it remains intact. Now, how much the employee gets and who's eligible is going to be the subject of the next slide. Hold on just one moment. And I apologize for hopping around a little bit. There's only 3 circumstances under which an employee can get 80 hours of pay. There's only 3 circumstances for which they can get $511 per day for this particular provision. And these are the 3 stated reasons, which by now you may have heard a lot about. It is where the employee is subject to a federal, state, or local quarantine or isolation order. Now, I will presuppose a question from the group, which is when the governor shuts down an industry or commands that everybody shelter in place, okay? When all of that occurs, that does not qualify under the first bullet point. Hope everybody understands that. It might if the order was more specific, but it does not under the present circumstances. So an individual would not get up to their full salary to a cap of $511 per day. So you'll know someone who makes $511 per day has an annual income of $132,860. So anybody who makes less than that in your organization is going to get their full salary up to whatever they make, not to the 511. The next person that becomes eligible for the 511 is someone that has been advised by a healthcare provider to engage in self-quarantine. That's when you call your doctor where you call the hospital and you are advised that based on what you are telling them, they're telling you to stay home. Under that circumstance, you would also be entitled to the 511 max. The third situation is where the employee, him or herself, is experiencing what appears to be the symptoms of the coronavirus and is in the process of seeking medical diagnosis. Now, that individual could fall under bullet point number 2 just as easily, because the medical provider that you're contacting could say, stay home, or the medical provider could say, please come into the hospital or to a center, get tested, and while that is pending, we want you to stay home. So it would fall under 2 or 3, depending upon the nuance of that instruction. Now, there's a second, so all of we're talking about here is paid sick leave for the employee who falls under the first 3 bullet points. All we're talking about. And this is where the confusion comes in, because the government then said, oh, but there's something called paid sick leave. And paid sick leave gives you 2/3 of your salary to a cap of $200 per day. If my math is correct, that is someone who makes up to $78,000 per year as their gross salary. And if they are caring for someone who essentially falls under the prior slide's first bullet point, where that individual has been quarantined by an order of a government or by doctor's instruction, and the employee who is giving the care for that individual would get up to 2/3 of their salary to a cap, $200. And I want to skip the next bullet point, and I'll come back to that. The last bullet point is if the employee is experiencing any other substantially similar condition, and it says here, as specified by the Secretary of Health and Human Services. I have to tell you, I'm not able to envision a circumstance in bullet point number 3 that is not comprehended already under bullet point number 1. I guess there's a fact pattern that it applies to, but I just haven't been able to see one or thought of one myself. The one that is getting the most, I guess, questions posed to John and myself would be bullet point number 2 on this page. What happens when an employee is staying home because their child is not sick, their child's school has been shut down, or if there's daycare involved, the child's daycare is cut down and is off. If the child is sick, they would fall under the first bullet point. But if the child is not sick and the employee just now has to stay home, that is a different message altogether. Now keep in mind that the 2/3 of pay is based on somebody earning $300 a day. $300 a day is $1,500 a week, and $1,500 a week times 52 weeks gets you to the $78,000. That's how the math is done, but there's a cap there, and the cap is 2/3 of that. So really you're talking about someone who makes no more than $52,000 a year would get the $200 per day max. Everything that we are talking about here on this slide, remember the employee, him or herself, is not sick, and the employee is not taking any paid sick leave. This is really a paid family leave because they are caring for a sick family member or they are caring for a child. In these situations, the cap on these numbers are for the same 80 hours. If we were to do a flow chart, you would see that there's pay coming up to 80 hours, and there'd be a split between the two. There'd be a fork in the road. 80 hours at 511 max would be for the employees quarantining and sickness, and $200 a day, 2/3 of pay to a cap of 200 for the 80 hours would be on another blade of this fork, and that would be for these reasons that are set forth here. Trying to advance, having a little bit of a computer snafu. Now there's something separate from this. This is paid family leave. This is effectively providing some form of pay for certain situations that would fall under the Family and Medical Leave Act for the same 12 weeks, but there'd only be pay for 10 weeks. First 2 weeks are not with pay, and the employee can take, at the employee's option, the right to use any PTO, vacation time, whatever it might be. Now, so what does all this mean? This is really where things get a little confusing, because it is the same $200 per day, 2/3 max that we have on the prior leave. So it gets confusing because in this situation, you are now taking care of a different family situation. I'm trying to sneak over to the next page. John, if you can do that for me. Now, the difference here is that, first of all, it only covers a child who is under the age of 18 whose school has been closed. It does not cover other areas of sickness. It does, and of course, under the normal FMLA, the person has to be employed with the employer for no less than 12 months, and there's a 1,250-hour eligibility period so they can take advantage of FMLA. Those changes under the paid family leave portion are that the employee, instead of having to work for an entire year, now can become eligible if they've worked for at least 30 days. And it is only for active employees. So if an employee has already been laid off prior to the commencement of April the 1st, and the act went into existence, someone who's already out on leave would not be entitled to this provision. Now, because this is so complicated, and because the Department of Labor has issued multiple and what appears to be, to John and to myself, contradictory materials and advice, the Department of Labor will not enforce anything against an employer who otherwise made a good faith attempt to comply with the law for a 30-day period. First of all, I don't think they have anywhere near the human resources to be able to monitor all of this, because now everybody is going to have to live up to this rule that is under 500 employees. And it's safe to say that the Department of Labor didn't have a sufficient number of investigators to investigate normal wage and hour violations, let alone this new law that they're still trying to pick their way through and figure out. All right, thank you. We're going to do a quick flyby over unemployment comp. And if we can go to the next page.
Sure. Thanks, Mark. And so, everybody, this is John Landesman. I'm going to speak now for about another 20 minutes or so, covering some of the other items on the agenda. And then we're leaving about 15 minutes to answer questions. And the best way, and really only way, to submit your questions, I believe that there's a questions box and you can type them. And if you want to, type them as we're going along, and they'll just sort of fill up, Mark and I will be able to read them and respond to them, as we get towards that Q&A period at the end of the seminar. So before I turn to unemployment compensation, Mark just spent about 25 minutes going over the FFCRA, the paid sick leave, the paid family leave provisions. Of course, in New Jersey, the situation for employers is that much more complicated, because not only do you have to comply with FFCRA, but in all likelihood, you're also looking at having to comply with a host of other laws and regulations in New Jersey. New Jersey now has New Jersey paid sick leave, which is up to 40 hours per year. It's basically 1 hour for every 30 hours worked. New Jersey has the New Jersey Family Leave Act. New Jersey has state disability and state FLA, family leave payments. 6 weeks for the disability, 6 weeks for the family leave at different rates of pay. And so an employer has to coordinate the FFCRA with those state laws that we were just reviewing and comply with all of the laws. For example, what does that mean? Let's just take a for instance. Let's say that one of your employees is sick, contracts COVID-19 and needs time off. Well, as Mark just said, for the first 2 weeks, how much are we going to pay that person? We're going to pay that person under FFCRA sick leave to a maximum of $511 per day. Their full pay up to that amount, which basically means that for most employees, except for really highly compensated ones, for the first 2 weeks, they'll get their pay under FFCRA. Okay, but let's take the example further. What if the employee continues to be sick and takes off another week? What do we do then? Well, for the additional time off, in addition to the 2 weeks, once that's expired, at the federal level, to comply with the federal law, we have to designate that time as FMLA qualifying, and the person, gets their 12-week entitlement to FMLA. So weeks 3 through 12, we would run that FMLA clock out to the extent the person continues to be out because they're sick. Would they get paid for any of that time? Well, when people are on FMLA, we can concurrently run and would run first their paid sick leave, so they burn out if they haven't used it yet. Their 1 week of the New Jersey paid sick leave. And then pursuant to our FMLA policy, we would also make the person burn out or use their PTO time and any vacation time. Would they also be eligible after they expire those paid time off, leave policies to dip into New Jersey disability? The answer is yes, they would. So New Jersey disability, of course, and this hasn't changed, it provides a 6-week benefit. The current max is $667 per week. That's the cap. It's 2/3 of pay to that cap. And by the way, that cap is scheduled to go up in July to, I believe, $860 a week. So, in that example, you can see that you're coordinating FFCRA, FMLA, along with New Jersey paid sick leave and New Jersey disability. And we have to coordinate all those laws and be aware of them. And it's certainly not an easy thing for employers to do. let's move on then. The other thing you need to be aware of course, in the midst of this pandemic crisis is unemployment compensation. So what's new in unemployment compensation? So employees are going to be eligible for unemployment comp caused by layoff or shutdown. They'll also be eligible if they're out of work due to furloughs as well. And a lot of people are using the term furlough and they're not really sure what it means. What's the difference between a furlough and a layoff? I guess it depends on who you ask, but for the most part, a furlough usually has a definite period of time. So you tell the people, we're laying you off on today's date, or we're furloughing you rather on today's date. We expect to bring you back on or before May 1st. And furloughs usually also involve the continuation of health insurance benefits, whereas temporary layoffs usually don't. By the way, if you're furloughing someone or if you call it a temporary layoff and you pay their health insurance, is the person going to be entitled to unemployment compensation, or is the payment of the health insurance going to disqualify them? The answer is that they'll still get it. They'll get the unemployment comp even if you pay for the health insurance. We know now also that the stimulus package, also known as the CARES Act, and I'll talk about that more later, provides that in addition to the regular benefit period for unemployment compensation, which in New Jersey is 26 weeks or 6 months, it's now extended under CARES for an additional 13 weeks. Also under CARES, if someone is unemployed due to coronavirus, they're going to be deemed eligible, and there's an additional benefit of $600 per week on top of the maximum state benefit. So, I've seen headlines, people call this unemployment compensation on steroids, and it truly is when you have individuals that could be, getting checks for unemployment of $1,200 a week for 9 months. Putting aside the legality of it as a policy matter, is it so rich that you're not incentivizing people to get back to work, that they're going to be content to stay home for up to 9 months and collect that amount of money? It's a question, of course, and it's being pretty vigorously debated in the press and elsewhere. Unemployment compensation, is the person going to be deemed eligible just because they refuse to work, not because a family member has coronavirus, not because they have symptoms, but just because they're scared, they're afraid? And I don't want to discount that. I mean, there's a lot to be afraid of, but as a legal matter, the people should not be deemed eligible for unemployment comp if they're just staying home and there's work available for them. So staying home because you're afraid is not going to result, or should not result, in unemployment comp being awarded. I say should not because the unemployment comp authorities that administer the laws are notoriously pro-employee when making these determinations. I put another bullet point in here mentioning the imminent threat under OSHA. There's a provision in the law that says that if there's an imminent threat, something that really poses a direct threat to the safety and well-being of an employee, then under OSHA's general duty clause, an employee can refuse to come to work. This is sort of an issue that hasn't been litigated yet, but do we think that the just mere existence of the pandemic creates an imminent threat and allows people to refuse to come to work just because they're afraid? No, we don't think so, and I doubt that OSHA or any unemployment comp referee is going to take that position. We'll talk about unemployment comp more in a few minutes when we get to some of the provisions of the CARES Act or the stimulus law. So let's talk about the CARES Act. Good segue there. First, I'm going to talk about a provision that really applies to smaller employers, 500 or fewer employees. It's the Payroll Protection Loan Program. So this authorizes disbursements of paycheck protection loans to smaller businesses. And the key here is that if you follow certain rules, primarily if you don't lay people off, the loans can be completely forgivable. So it's almost not appropriate to call them a loan. It's really free money or a grant. How do you get it? How much can you get? Let's talk about it. So the government earmarks initially almost $350 billion for this particular loan program. Again, it's small businesses, 500 or fewer employees. And by the way, that's full-time, part-time, everyone gets counted, temporary, seasonal, as an employee, and that's the way that they count it. There's a certification that's required where you say that your business has been affected by COVID-19, but it's not a high threshold. There's really no hardship standard or hardship test that you have to meet. Frankly, there's no underwriting involved in these loans. They're not asking, the borrowers for personal guarantees. They're not basing it on credit. They're not basing it on need. It's really just now, talking to bankers and accountants and a lot of clients about it. It's a race to get these applications in because the fear is that even though it's a lot of money, $349 billion, that it's going to run out and it's going to be first come, first served. And once the funds are depleted, there won't be anything left. Excuse me. So, what can you? How much can you take out? What can you use the loan for? Let's talk about those questions now. So, you can take out the loans and apply. And they said February 15, even though the law didn't pass. All the way up until June 30th, although again, the funds could be depleted by that point in time. And so getting the applications in and contacting your banker really today, there's no reason to wait. It should be sooner and not later if you think that you qualify for this. And what can you use the money for? You can use the money to pay the wages of your employees up to a cap of $100,000 annualized. You can use that money for health insurance, 401k, other fringe benefits. You can also use, and you can use the loans, and it doesn't say this here, but they can be used to cover rent, certain mortgages, if it's a business mortgage expense, or interest on debt that you're carrying for the business. How much can you borrow? How much can a company borrow? So the amount that you can borrow is either 2.5 times your average monthly payroll cost or $10 million, whichever is less. So it's the lesser of that. So for a lot of companies, unless you're a larger business, it's going to be 2.5 times your payroll cost. How do you calculate your payroll cost? Again, we have to apply that cap of a maximum of $100,000 per person, but we can add in certain state payroll taxes. You can add in the cost of benefits and health insurance, and then the multiplier is 2.5, and that's the maximum amount of the loan that you can get. What can we use the loan for? And I mentioned this earlier. The payroll, the rent, the utilities, the interest. For what period of time can you use that amount of money, the 2.5 times your payroll? So you apply for the loan. Let's say you get your loan application in today, April 7. Everything goes great. It flies through the underwriting process, and you get your check, the loan funds, on April 21st, or I'll make it easier. On May 1st, you get your check. Well, then for a period of 8 weeks from May 1st, using my hypothetical, the date that you get the check, for that period for 8 weeks, so basically the months of May and June, using my example, you can use the loan proceeds to pay all of these things that are listed here on this slide: the payroll costs, the rent, the utilities, the interest, and the loan is going to be forgiven in its entirety, subject to two exceptions. And they have formulas to determine how much of the loan is going to be forgiven. The first formula, I have it laid out here in the second bullet point. It's basically the percentage of people that you continue to employ during that period of 8 weeks when you're using the loan versus either the number of people you have employed in the first 2 months of the year or the number of people you had employed during a 6-month period of 2019, whichever calculation is more favorable to you. And then the loan forgiveness also, percentage of that loan forgiveness can go away if you cut your people's salary by more than 25%. So again, the loan is forgiven in its entirety unless A, you cut people's salary by more than 25%, or B, you lay people off. If you don't do either of those two things, the government will pick up the tab for the whole loan. If you do one of those two things, it doesn't mean that you have to pay back the whole loan. It means that a percentage of your loan would have to be paid back. So if you lay off 10% of your people, you'd have to pay back 10% of your loan instead of having the whole thing forgiven. Let's turn to the next subject under CARES. And again, I want to leave time for questions, so I'm going to go through this a little more quickly. And I think we talked about a lot of this. CARES extends unemployment for an additional 13 weeks. So instead of the 26 weeks of unemployment, they get 39 weeks. And again, on top of the state maximum that they'd be entitled to, bang, we add another $600 per week on top of that. Now let's turn to some general information regarding operations and layoffs. Marc, I don't recall, did you want to cover some of these slides, or did you want me to go over them?
You're certainly more than capable. You're on a roll, so I'll jump in. Anything else to add?
All right. Well, feel free to jump in. And again, I'd remind people if they have questions that they can post them, and hopefully in just another couple of minutes, we're going to get to those questions. So, we've been fielding calls 24/7 for the last couple of weeks, unfortunately, about layoffs. When I'm laying people off, can I just lay people off in any order that I want? Let's say I have an accounting department and I've got 4 accounting clerks in my accounting department. Can I just pick and choose willy-nilly which ones I'm going to lay off, which ones I'm going to keep if I need to, and I have to lay 2 off? The answer is no. We have to be mindful of potential discrimination claims, and usually we don't see claims based on race or ethnicity or gender. You laid off all the women, you laid off all of the African Americans, although that could be a possible claim. But usually what we see are claims that are age bias claims. You laid off all of the older workers. And why does that happen typically? Well, a lot of times the older workers are the ones who are there longer, and they're the ones who get paid more. And so, conducting your layoff and saying, I want to lay off all of the people who make the most among those 4 accounting clerks, that's probably a recipe for a problem, because you're going to wind up laying off only the oldest people in each department. You want to be very mindful of that. How do you combat that? The easiest way is to just follow a strict rule of seniority. So the most recent person hired is the first one to be laid off. And whenever I tell that to a client, a business owner, they say, my God, John, I don't want to follow seniority. I want to keep my best people. I don't want to just keep people based on seniority. I'm not a union contractor here that's bound by these ridiculous seniority rules. And my answer to that is, okay, if you want to deviate from seniority, that's fine. but you better be able to defend that position. Show me a performance evaluation. Show me some objective data that shows me why employee A is better than employee B, especially if there's a disparity in their ages and employee B has been employed with you for a longer period of time. The other thing to consider with layoffs, do you want to get a release from the people? Are you providing them with severance? Do you want to have them continue to be bound by confidentiality agreements, non-disclosure agreements, and or non-compete agreements? There's no hard and fast rule that says that someone who is laid off is automatically released from a non-competition agreement, although the courts will weigh that as a factor and can certainly be used against the employer. It's one factor to consider here when we're looking at selecting who to lay off. The other thing, of course, as I just mentioned, when you're conducting layoffs, is to think about the loan forgiveness impact to the extent that we are a company that is going to take advantage of the payroll protection program. Layoffs, when you're conducting layoffs and you're a larger employer, there are these laws out there called the WARN Act. There's a law that's similar at the state level in New Jersey. It requires that you give notice to the people, at least 60 days notice, before implementing what's called a mass layoff. Again, this generally applies only to larger employers. If you have questions about the WARN Act or the state WARN Act, because we're running short on time, please feel free to pose those questions or reach out to Marc and I, and we can get into that very technical area of the law. There's some other questions that have been posted to us. And by the way, if you're looking for information, I'll give us a little commercial. If you look on our firm's website, www.cohenseglias.com, you'll see that we have set up a whole section called the COVID-19 resource section of our website. And it's because we represent well over 1,000 contractors, it's for construction contractors, and it has information on FFCRA and a lot of the other things that we've just been talking about. There's an article with more detail on the loan program, and there's probably 20 different postings now that have all sorts of forms on construction issues and other things, force majeure, all those things that you're probably thinking about as a contractor. So I would encourage you to take a look at that resource. These are some of the questions also that I think are posted on that site. And so, question, can I, as an employer, require my employees or if I have someone who tests positive, am I required to disclose that positive test to anyone? And the answer is yes, there are disclosure obligations, including to the Department of Health and the CDC. Question, can I take an employee's temperature as they're entering into the workplace? Am I allowed to do that? Answer, yes, the EEOC allows that. I've heard a lot of companies that are doing that have engaged nurses or other people to do that, saying that the cutoff that they use is 100.4, but I guess there's some debate about that. Can I send someone home if they are exhibiting symptoms? Well, yes, of course you can. When making disclosures about people who have symptoms or have tested positive, do I have to respect their privacy rights, or can I mention them by name? And the answer is, in most cases, we're recommending that you're not disclosing the names of the individuals to protect privacy rights under HIPAA. And that is, sort of a quick overview of the questions that we've been receiving, although there are many others. Now we'll open it up for questions if anyone has and I know that there are a lot of people on the line with us, and we have a question here. Let's see if I can expand this. So the question is from one of our participants. Can an employee whose child's school is closed take leave under the new program, even if the company has provided them a way to work remotely? So, Mark, did you want to address that one, or would you like me to take that?
That's too hard, John. I'd rather you take it.
So, the Department of Labor, I guess it was on the 2nd, so 5 days ago or so, issued a big question and answer. It was a 124-page document, and it took a while to get through it, frankly, that talked about telework and making telework available. And can the person take the leave under the new program, even if you've provided a way for them to work remotely? I believe that the answer is yes, they can still take the leave. What I saw in that guidance was a provision that said that if they're not the primary caregiver and they have a spouse who's staying at home caring for the children, that they cannot also take the FFCRA 12 weeks of leave. But, denying them this federally entitled right and offering them telework as an alternative, I believe is not permitted under the regulations. I can double check that, and if the writer of that question, I can circle back with them, but I'm fairly certain that that's the answer. Let me just see if we have any other questions that are posted. And again, I would encourage you to ask. I'm not sure if I'm looking at this correctly. Do you see any more questions posted, Mark, on our?
No, I only see the one question that you just answered.
Okay. Well, then I would encourage anyone. We'll give you a minute or so. We can answer questions. Mark, do you have any other thoughts or just closing remarks? We only have another 5 minutes or so here.
Well, I do want to emphasize a couple of points, and that is that while the state of New Jersey has not declared construction to be forbidden, clients are calling us up with the strange position that the governor said it's okay if they keep working, kind of implying that the employees, the construction workers, are not capable of getting the virus because the governor said it's okay to work. It is still a very, very serious situation, and it has been our advice that the sooner we can get rid of this virus, obviously, the better for everyone, and that it is more doable the less we have interactions with others. So if that means that you can work but don't have to work, or that you can't, you're capable of working remotely to the extent that you can, do whatever you possibly can to provide the safest work environment for your employees and essentially for everybody else around you. A lot of the people on the phone may also do work in neighboring states, and we know that Pennsylvania is very much different from New Jersey in that regard, and that in Pennsylvania, construction generally is not to be performed except if it's of an emergency nature in a hospital-related situation, or it is work to be performed in a school district where the school districts themselves are not covered under the Governor Wolf's order to stay at home, but the individual school districts can decide on their own as to whether they think that the construction involved would be necessary and therefore it should continue. So there's different rules in different jurisdictions, and if you're working in more than one state, you're going to need to have to follow whatever the dictates are in the state where the work is being performed.
Okay. Mark, we've got two other questions. One question is, if you're an essential business in construction, are all employees, even clerical, considered essential as well? I'll answer that one. So we're talking about in New Jersey an executive order. It's Executive Order 107, if you want to actually look at it. And it essentially says that to the extent that a business is exempt, it's essential and allowed to continue. The law says that for employees that are not performing work that is essential, that to the maximum amount you should allow them to work from home or not require them to work at all. So just because your business is doing some sort of essential work does not mean that you should have all of your employees working in the office like it's business as usual. 107 says that you should do the opposite. Another question, I can throw this one to you, Mark, if you'd like. Do you know how the unemployment claims related to coronavirus will affect SUTA or the unemployment comp tax rates?
I have absolutely no idea.
Okay, well, I have a small idea because we looked at this issue for one of our clients. In Pennsylvania, the answer is very clear that coronavirus-related claims are not going to count against the employer's experience rating. There won't be any effect to the employer won't be charged. Their tax rate won't go up in Pennsylvania. And I believe we looked at it. The answer wasn't as crystal clear, but it appeared that the same thing is going to apply in New Jersey. In Pennsylvania, we had specific guidance issued by the Department of Labor. In New Jersey, I think they indicated something, but not as clear, but it pointed in that same direction.
I did want to just pose another point. We have a minute or so left. We might as well give you your money's worth. If you are in a support industry, such as you are a fabricator of sheet metal, and you are located in New Jersey, even though you're not in a construction business per se, because you're not physically doing the installation, you would likely be considered a supporting industry, and therefore you would have a right to continue to manufacture and fabricate your ductwork in the shop so that the job site can continue. This would be particularly true even in Pennsylvania, where the job site is a hospital or healthcare facility. And clearly, while the people can work on site in both states under that scenario, they would have nothing to install doing HVAC work if the off-site fabrication through a supplier of sorts was not available to do that work.
Okay, and there's one other question. I'll answer it real quickly, and then I think we're going to wrap up. The question is, it relates to force majeure or impossibility of performance. So that's a question. Marc and I are labor and employment lawyers. We're not construction lawyers, but fortunately, we've got about 40 construction lawyers back at the office. I know that we've got an article written that addresses those exact topics, force majeure and impossibility, and it's on our website if you want to check that out. And if you want to get a more detailed or specific answer to your situation that you're dealing with, you can contact Marc or I, and we'll put you in touch with one of our construction law partners who can talk about that intelligently. It's sort of beyond the scope of our area of expertise. So you see in the contact slide there that we have our numbers listed separately because we're both working remotely. So those are our cell phone numbers and our email addresses. If you have a question or any follow-up, we'd be pleased to speak with you and address those items. And I want to thank, of course, ABC of New Jersey for hosting this. I think it was a great service for the chapter members. And again, if you have any questions, feel free to contact us. Marc, any closing words?
Just be safe out there.
Well said. All right, we're going to sign off. Thank you. Bye-bye.
Bye.